Hi there, I'm immigration attorney Heather Poole. Did you file an I-601A, go to your consulate interview, and then were refused your visa? Then this video is for you. Let's see what your options could be. The provisional waiver is a great solution for many, but there are many pitfalls and consulate decisions are non-reviewable. There's no appeal of a consulate denial. Just because USCIS approved your provisional I-601A waiver does not mean that the consulate, which is part of the Department of State, a totally different agency, will allow you to keep that waiver approval. USCIS used to look deeper at I-601A filings to determine if there were other potential grounds of inadmissibility. But are no longer really doing this. They're leaving it up to the consulate to dig into your past. In many instances, this can result in the consulate finding another ground of inadmissibility besides unlawful presence. Another reason why, under the law, you don't qualify for the immigrant visa without an additional waiver. And since I-601As only waive unlawful presence, if the consulate during your interview finds another ground of inadmissibility, your I-601A will be revoked and canceled. And you have to start over, but this time from outside of the United States. If this happens, what can you do? In some circumstances, an attorney may be able to get the consulate to reverse an inadmissibility finding and reinstate a denied I-601A if the consulate was wrong in its legal conclusion about an additional inadmissibility ground. This can occur, for instance, if the consulate finds that your conviction for a theft crime was a crime of moral turpitude under federal immigration law, a crime that must be waived with a CMT waiver before you can be issued an immigrant visa. But perhaps in the federal circuit court that has jurisdiction over the state statute that you were convicted under, say you were convicted of a crime in California, then the Ninth Circuit's interpretation of that crime would dictate whether it was a crime of moral turpitude. You or your attorney could provide the consulate with proof that the circuit court has found the crime that they think is a CMT is actually not. It is possible to challenge wrong consulate decisions, but this is usually a longer process, and you must weigh the pros and cons of waiting for this challenge to be resolved versus just filing a new traditional I-601 waiver given the backlog in timeline and the unknown timeline for an inadmissibility challenge with the consulate. Sometimes the consulate will get back to you in a matter of weeks, sometimes many months. Even if you receive a response for the consulate, it may just be to affirm what the consulate stated before. The consulate may refuse to reverse its original CMT finding, for example. This doesn't mean that the consulate was necessarily right, but it does mean that you would have to go up the chain outside the consulate to the Department of State's Legal Advisory Board to try to get the advisory board to convince the consulate to reverse its decision. This can, again, take many months or even over a year to receive their decision, and there's no guarantee, even if their interpretation with the law is the same as yours or your attorney's, that the consulate will adhere to the advisory board's advice and reverse its finding. All of this needs to be weighed in to determine if you really want to file an I-601 because of the unknown processing times on challenging the inadmissibility finding. There are times when it may be best to hedge your bets, challenge both a clearly legally wrong inadmissibility finding by a consulate, while at the same time filing the waiver with USCIS, even if done under protest, so you can at least get into line if you need the waiver in the long run. So what kinds of inadmissibility findings have the best chance of being reversed? One, those where the law in your jurisdiction has clear case precedent on the criminal issue that is in your favor. Two, those that do not match up with the Department of State's own internal guidance or policy. Note that issues of policy interpretation of inadmissibility where Department of State policy may not match up to CIS or CBP policy, which is the Department of Homeland Security, and you're relying on CIS policy to dictate the consulate's finding, are much more difficult to win and are not so clear-cut.